Generally, attorneys may be liable to their clients in both contract law and tort law for malpractice if they breach their professional duty of care. But does an attorney who drafts a will for a client owe a duty to non-client third parties who are contemplated beneficiaries under the will? And may such beneficiaries sue the attorney for malpractice if they're unable to take in the intended testate's succession due to the attorney's professional negligence? In Lucas v. Hamm, the California Supreme Court addressed these issues in a case involving an attorney who drafted a will that violated the rule against perpetuities and restraints on alienation. Eugene H. Emmick hired attorney L.S. Hamm to draft his will. In furtherance of his testamentary goals, Emmick told Hamm that he wanted to include a testamentary trust in his will, in which Robert Lucas and others were to receive 15% of the residue of his estate. Hamm then drafted Emmick's will, and Emmick signed and executed it. Following Emmick's death, his will was admitted to probate. However, because of errors made by Hamm with respect to the rule against perpetuities and restraints on alienation, the provision of the will creating the testamentary trust for Lucas and others was declared invalid. In a will contest brought by Emmick's relatives after admission of his will to probate, Lucas and others settled for $10,000 each. However, the $10,000 was $75,000 less than what they would have received under the will, but for Hamm's error. Subsequently, Lucas and others sued Hamm in state superior court for malpractice, seeking damages for what they would have received under Emmick's will, but for Hamm's negligence. In response, Hamm filed a demurrer, asking the court to dismiss the complaint because he didn't owe Lucas and others a duty of care in drafting the will. The court granted the demurrer and dismissed the complaint. Lucas and others then appealed to the California Supreme Court.